And greetings. Welcome to Judgements, Operation, Effect, and Validity from American Jurisprudence. I'd like to greet you all, show it up here tonight. We're going to go over something that affects the outcome of all of cases or controversies that come before courts. They are to end in some type of a judgment. So let's find out what these are all about. Indeed, Metal, this is going to be some good stuff. That being said, please, if you just joined or just heard about this, hit the like, make sure that the word gets out, and get some people in the room, and let's get started. So, we're on to American Jurisprudence 46 from 2nd edition, American Jurisprudence, Judgments. So this first part is the summary. The scope. This article discusses the general principles of law applicable to judgments in civil actions, including the operation, effect, and validity of judgments, and judgments in cases involving multiple claims or parties. The article also discusses rendition of judgments, entry, recording, and docketing, lien of judgment execution, dormancy, revival, or renewal, assignment of judgments, conclusiveness, res judicata, and collateral estoppel actions on judgments, satisfactions of judgments, and the nature of and general principles applicable to various types of judgments, such as consent judgments, judgments by confession, judgments by default, and judgments in rem. The article also contains a detailed discussion of various types of relief available against judgments, such as opening, modifying, and vacating judgments, equitable relief, and collateral attack. Principles of conflict of laws applicable to judgments are considered. So this has quite a wide scope. And as you see, there's many different types of judgments and the principles that apply to them. So there's going to be federal aspects, the principles applicable to judgments rendered in the federal courts, and pertinent provisions of the federal statutes and federal rules of civil procedure are considered in this article. Also discussed are the constitutional guarantees of due process relative to the validity of judgments, which we'll be getting over the validity of judgments and the guarantees of due process relative to that. The recognition required by the full faith and credit provision of the United States Constitution to be accorded in one state to judgments rendered by courts of another state is discussed. And that's in American, okay, that's in executions. Just a moment here, guys. Let's get this back in action here. What happened there? Okay, we get to our book. And just a moment here. Let's just refresh this, and that's, I think, we'll take care of it. And there we go. Okie doke. So we're back. There we go. All right. Once again, let's zoom back in here and continue. So these are all the other areas in American jurisprudence where various aspects of judgments might apply but are not covered in this article. So let's continue on here to Section 1, Definition and Function of a Judgment. And before we do that, let's jump over the chat, make sure we get everyone in here and everything's coming in nice and clear. Many, so complex. Yeah, and it seems the more complicated things get, but when you want to consider that an overall process and methods of justice, that this way it pretty much is going to address a wider scope of controversies, and of course the ones that require the most attention. So that's where the judgments are needed, and that's what we're going to focus on. So the definition and function of a judgment. A judgment is a judicial act of the court which fixes clearly the rights and liabilities of the respective parties to the litigation and determines the controversy at hand. So the judgment determines the controversy at hand. It clearly fixes rights and liabilities of the respective parties to the litigation. It is the court's official decision with respect to rights and obligations of the parties to a lawsuit with respect to the claims involved, or upon matters submitted to it in a proceeding. A judgment is the final consideration and determination of the respective rights and obligations of the parties, as those rights presently exist upon matters submitted to it in an action or proceeding. So we have a cause of action or some proceeding that was submitted to the court. So, as such, a judgment does not look to the future in an attempt to judge the unknown. So, to the matters submitted to it in an action. That's the only thing a judgment looks to, not to the future in an attempt to judge the unknown. A judgment must dispose of all the issues involved so that no further action by the court will be necessary in order to settle and determine the entire controversy. It is the final decision of the court, resolving the dispute and determining the rights and obligations of the parties, and the law's last word in a judicial controversy. So the judgment is the law's last word in a judicial controversy. Its function is to conclude the controversy between the parties. A court renders its final determination of the rights and obligations of the parties in a case in its judgment. So that's where the final determination of rights and obligations lie. A judgment must be sufficiently clear and definite so that it is susceptible of enforcement. That's interesting. Susceptible of enforcement. That must be sufficiently clear and definite. And those called upon to understand and obey it must not be misled or called upon to pay more than is due. So the judgment must be clear and definite, and so it's susceptible of enforcement. So I guess that means that it's clear and defined enough that enforcement is readily applied when needed, and those called upon to understand and obey it must not be misled or called upon to pay more than is due. So we don't want to see an abuse of judgment. It also must be in such a form to enable a clerk to issue an execution upon it, which an officer will be able to execute without requiring external proof and another hearing. So it must be in a form, the judgment's in a form to enable a clerk to issue an execution upon which an officer will be able to execute. So a clerk issue an execution which an officer will be able to execute without requiring external proof of another hearing. I think something like warrants, things like that, would also possibly fall into that category. If a writing is to be considered a judgment, it must clearly show that it is the final act in the proceeding and an adjudication of the issues involved. A paper filed in an action does not become a judgment merely because it is so entitled. It is a judgment only if it satisfies the criteria of a judgment. Right? Sufficiently clear and definite. All these criteria that we went over here. Just because they called a judgment doesn't mean it's a judgment. It doesn't become one just because of a name. Only if it satisfies the criteria of a judgment. And that's from footnote 19. We have here an observation. A judgment, in the most general sense, is a judicial act that establishes the rights and liabilities to the extent possible in a particular suit, while orders, opinions, verdicts, and other declarations in a trial court are the building blocks for a judgment. Wow, interesting here now. So this is a very important distinction. Before we go further, just to remind everyone that This is strictly an entertainment educational broadcast, not to be construed or interpreted or used for anything professional, personal, monetary, financial, tax-wise, legal, lawful, or otherwise. Please don't do this at home. Let's continue. So this observation here is explaining that the difference between a judgment and an order, opinion, a verdict, or other declarations in trial court. That the judgment is an act establishing rights and liabilities to the extent possible in a particular suit. These orders, opinions, and verdicts and other declarations are just building blocks for this judgment. That they in themselves, an opinion is not a judgment. A court order is not a judgment. A verdict is not a judgment. And neither declarations in the trial court a judgment. The act of the court or judge in pronouncing judgment, accompanied by the making of the notation on the trial docket, constitutes the rendition of the judgment or decree. There must be a final determination of the rights of the parties before there is a judgment to either be rendered or entered. Interesting. So now we have some additions here to the footnotes. We have, from this 1965 appellate case, the word judgment refers to different things in different contexts and is often used generally to refer to the result of any kind of judicial decision-making process. Okay, and then we have a judgment means a formal decision. A formal, going through a form, the decision or determination. Remember that the clarity that needs to be one of the criteria of it, right? Sufficiently clear and definite. And this was actually from footnote 16, which we'll get to soon. But a judgment means a formal decision or determination given by a cause, given in a cause by a court of law or other tribunal. That's the 2009 case, Wachovia, Washington. Oh, interesting here. So the judgment, this is actually giving a distinction, it seems here. As to the distinction between the judgment and the decision, see section 6, which will be there shortly. Okay, as the contents of judgment, some of these sections we're not going to get to. We have validity of judgments, which we should be getting to soon, as well as distinction between judgments and other documents and statements. All right. Now we get on to section 2, the basis of judgment. Let's hop on over to the chat here. Court orders a way for them to steal rights. Court orders, I guess, is a way of them enacting certain aspects. It depends on which side you would be using that court order. Court orders can be very useful too. And everything hangs on the precise meaning of terms. There's words, every word has a different meaning. That's why they're different words. So that's, I guess, at the essence of it, isn't it? Well, that being said, let's continue on the basis of judgment. A judgment is the final results of pleadings, evidence, and law in a case. So judgment is the final result of your pleadings, evidence, and law in the case. Judgment must be supported by pleadings that allege applicable legal theories and by competent evidence. A judgment based on an issue not pleaded is a nullity. Similarly, an issue depending entirely upon speculation, surmise, or conjecture is never sufficient to sustain a judgment. Orders purporting to be final judgments, but are dependent upon the occurrence of uncertain future events, do not operate as judgments and are wholly ineffective and void as such. Uncertain future events. Moreover, since a judgment is the determination of the rights of the parties in an action, a judgment cannot determine the rights or award relief to persons or entities who are not parties to the litigation. Okay, very clear here to define the boundaries here. Definition and nature of judgment. as to an agreed case as the basis for a judgment, see agreed case. Section 28. As to the conformity of a judgment to a pleading, see under pleadings, and a judgment is generally defined as a pronouncement which determines the matter submitted to a court. Determines. As the party subject entitled to, okay. All right, we get on to Section 3, Judgments, distinguished from decrees. That's an interesting one there. Judgments and decrees. Yeah, if they are not for future purposes, then why do they set precedents? That's a misnomer too, because what they are not setting is precedents, but in the future you may refer back to these cases as using the same logical thought patterns in reference to natural justice that would render the same decision, perhaps. But it would not imply future choices at all, although some people sometimes construe it as such. But yeah, correct there on that distinction. It does not, precedent is not something that's going to influence a future, although it would put that cloud of uncertainty for sure to anyone, and perhaps a chilling effect because of that ruling being brought back as a support for a particular logical thought or reasoning for law. So we're on to the judgments, distinguished from decrees. The terms decree and judgment are interchangeable in some jurisdictions. In some jurisdictions. For purposes of the federal rules of civil procedure and some state rules of procedure, a judgment includes a decree and any order from which an appeal lies. So it includes a decree and any order from which an appeal lies. A judgment, in quotes here, is a court's final determination of the rights and obligations of the parties in a case. And the term judgment includes an equitable decree and any order from which an appeal lies. Generally, an equity court's decision is termed a decree, and the decision of a court of law is termed judgment. So, there we go. Here's your little legalese nuance right there. A decree is typically an equity court, chancery and such, and judgment is decision of the court of law in some jurisdictions. All right, let's move along here. On to Section 4, judgments distinguished from orders. Someone just asked me about orders. An order may be defined as any other determination by a court or judge which is intermediate in nature. So this is in between. For purposes of the federal rules of civil procedure, a judgment includes a decree and any order from which appeal lies. So any other determination by a court or judge which is intermediate, it's not final. So observation, a judgment is an order, but an order is not necessarily a judgment. A judgment's a final order, it seems. There we go. You get that? Observation. A judgment is an order, but an order is not necessarily a judgment. Although the terms order and judgment are sometimes used interchangeably, the term judgment normally refers to a court's final ruling. A judgment is distinguished from an order in that the latter is the mandate or determination of a court on some subsidiary or collateral matter, arising in an action not disposing of the merits, but adjudicating a preliminary point or directing some step in the proceedings. As a judgment must function by its character as a final determination of the parties' rights in a lawsuit. Whether a document is a court order or judgment is to be determined not by the document's title, but its contents. Every direction of a court or judge, made or entered in writing and not included in a judgment, is an order rather than a final judgment. Do you get this? Every direction of a court or judge, made or entered in writing and not included in a judgment, is an order rather than a final judgment. Observation. A judgment, in the most general sense, is a judicial act that establishes the rights and liabilities to the extent possible in a particular suit, while orders, opinions, verdicts, and other declarations in a trial court are the building blocks for a judgment. We read this before, and they like to really hammer it in when there are important observations here with American jurisprudence. So that being said, it behooves us to really pay attention to these observations. And that was from footnote 8. So while we're really diving into this, as from Gordon versus Gordon, 2006, as to the definition and nature of judgment, see section 1, which we did. So let's see what else we have here. Judgment from decrees, we saw that. Decrees are typically from chancery or equitable courts. Review on additional issues allowed and decision on other grounds. When a trial court enters an order directing counsel to prepare a judgment entry consistent with the order, this constitutes a mere pronouncement of the court's findings and is not the court's final judgment. So an entry consistent with the order, right? Prepare a judgment entry consistent with an order. That's a mere pronouncement of the court's findings and not a final judgment. That's a very recent case, 2016, Ohio. So interesting to see how the common law is still, to this day, being molded for the finer and finer nuances with judgments. Let's go on to the chat here real quick. There's court orders that stop people from recording in a courthouse. Are ways they steal our rights. How are they enforceable? By consent. It just takes, it would take an action to go against that. And if a judge wanted to excuse a juror for illness, would that be an example of an order? Typically, I believe so, with cause. All right, let's go along here. Section 5, judgments distinguished from verdicts, findings of fact, and conclusions of law. All right, so we have some other aspects of the court and judicial determinations here that we can further finally define. Although the acceptance and recording of a verdict under the direction of the court may constitute a judgment entered on a jury verdict is a legal concept separate and distinct from the verdict. A judgment entered on a jury verdict is a legal concept separate and distinct from the verdict. A judgment in the most general sense is a judicial act that establishes the rights and liabilities to the extent possible in a particular suit, while orders, opinions, verdicts, and other declarations in trial court are the building blocks for judgment. Boy, we keep hammering on this. So it's being applied to the acceptance and recording of a verdict under the direction of a court. May constitute a judgment. It doesn't shall, but may. A judgment entered on a jury verdict is a legal concept separate and distinct from the verdict. So the judgment establishes rights and liabilities, while orders, opinions, verdicts are building blocks for that judgment. So when a jury verdict is a legal concept separate and distinct from the verdict. A judgment entered on a jury verdict is a legal concept separate and distinct from the verdict. So the judgment of the jury is a legal concept separate from the verdict of the jury. So a judgment is also distinct from the findings of the court. As a general rule, the findings of the court do not constitute a judgment or decree, but merely form the basis on which the judgment is subsequently to be rendered. A judgment is something more than the findings of fact. It is a sentence of law pronounced by the court on the facts found. This rule has been applied not only to findings of fact, but also to conclusions of law stated by the judge, whether made during or after the trial of the case. So that's an important rule, general rule. Findings of a court do not constitute a judgment or decree, but merely form a basis on which judgment is to be subsequently rendered. So that's applied not only to findings of facts, but also to conclusions of law stated by the judge. So a conclusion of law stated by the judge cannot be a judgment, right? It merely forms the basis on which judgment may be rendered. All right, so here's another observation. A finding of fact precedes the judgment and constitutes an opinion for the ground of the judgment, but is not a final determination of the rights of the litigants in the subject matter of the action for purposes of appeal. The efficacy of the judgment does not reside in any prefatory statement of reason or recital, but in the mandate of the decree. So the efficacy of the judgment is not in any prefatory statement of reason or recital, but in the mandate of the decree. So under what authority they can make that decree. Interesting here. And that's from footnote 9. Autumn Ridge Homeowner Association, geez, 2010, in misery. The factual recitations or reasons preceding the decretal portion of a judgment form no part of the judgment itself. So the facts form no part of the judgment. The judgment is a process of reason built on the facts. Judgment is the final amount of money due to the plaintiff. A judgment is the final amount of money due to the plaintiff, consisting of the verdict. The verdict is part of the cost, the final money. The costs of the litigation, the fees for the litigation, and interest. Wow, that's a 2007 case. So we're on to section 6. Judgments distinguished from decisions. Ooh, really splitting hairs here. All right, and I see that we're doing good here on the chat. Let me just refresh, make sure it's all there. All right, here we go. Interest 2. You don't hear that much, do you? But now you see there's a case you can refer to where that interest does matter. That's, let's see. That was from our observation. Let's see, was it? No, it wasn't. Let's see, no, it was down here. Here we go. Oh boy, lost that one quick. Here it is. A judgment is the final amount of money due to the plaintiff, consisting of the verdict, the costs, the fees, and interest. That's North Carolina Industrial Capital LLC versus Clayton, and that's in North Carolina, 2007. There's your information. Let's continue. All right, we're on to judgments distinguished from decisions. A distinction is occasionally made between the terms decision and judgment of the court. As a general rule, the decisions of a court do not constitute a judgment or decree, but merely form the basis on which the judgment is subsequently to be rendered. A decision announces what judgment will be, while a judgment unequivocally orders the relief. So a decision announces what a judgment will be, while a judgment unequivocally orders the relief. A decision, therefore, has no real legal significance, notwithstanding that interlocutory decisions or motions often tell parties who has won. So, of course, yeah, this is in between the actual proceedings. They'll probably have motions and decisions letting you know where the case is going and to get prepared for calculating reliefs. Until there is a judgment, the judge's conclusions and decisions are subject to change. Until there is a judgment, the judge's conclusions and decisions are subject to change, even if there are these interlocutory decisions. All right, and we're on to section 7. Judgments distinguished from opinions. There is a distinction between a judgment of the court and its opinion. As a general rule, the opinions of a court do not constitute a judgment or decree, but merely form the basis on which the judgment is subsequently to be rendered, and are not conclusive unless incorporated into a judgment. The mere ruling, decision, or opinion of the court, no judgment or final order being entered in accordance therewith, does not have the effect of a judgment, and is not reviewable by appeal or writ of error. So the ruling, decision, or opinion is not reviewable by appeal or writ of error, only the judgment. The opinion does not necessarily form part of the judgment. A trial court's reason for a judgment, while defining and elucidating a case, form no part of the official judgment. It signs and from which appeals are taken. So reasons, while defining and elucidating a case, form no part of the official judgment. So think about that from terms of appeals, right? The reasons for the judgment, right? And it's really about elucidating a case. So the reasons for the judgment form no part of an official judgment. It signs and from which appeals are taken. If the judgment rendered and its legal effect, it is the judgment rendered and its legal effect, and not the reasons and arguments in support thereof expressed by the judge in his order or judgment, which constitutes the adjudication. So again, the judgment rendered and its legal effect, it's not the reasons, thus would be appealable. So if it's something where the appeal would lie, it would be in the legal effect of a judgment rendered, not the reasons and support thereof expressed by the judge in his order or judgment, which constitutes the adjudication. So it's the legal effect of the adjudication, not the reasons supporting or led to it. It is only what a court adjudicates and not what it says in an opinion that has any direct legal effect. Nevertheless, the signing of an opinion may, for certain purposes, be regarded as equivalent to a pronouncement of judgment in an open court. All right, so we have a little bit of nuances here as the definition and nature of judgment. And an oral opinion by a trial judge discussing and purporting to decide the issues is merely an informal statement of his views, and not itself the decision of the court or a judgment. And an opinion in favor of the plaintiff in an action for money, which embodies the essential elements of a judgment for money, and clearly evidences the judge's intention that it is to be the final act in the case, constitutes a final judgment. So money helps bring action to bring final judgment and constitute that. It clearly evidences the judge's intention that is to be the final act. They want money, they got money, that constitutes the final judgment. All right. Now we're on to Section 8. What law governs judgments? The effect of a judgment is determined in accordance with the law in force at the time of its rendition. The validity of a judgment, likewise, must be measured by the law in force when it was rendered. After enacted legislation cannot impair the efficacy of a valid judgment. Judgments in federal courts are governed largely by the federal rules of civil procedure. As to judgments of other states, the general rule is that the force and effect of a judgment are determined by the law of the state where the judgment was rendered. In contrast, while the substantive law of the state where the judgment is entered controls the effect of the judgment, the forum state's procedural rules control how that effect is determined. Whether a party is entitled to summary judgment is a matter of procedure generally controlled by the law of the forum. Stated another way, summary judgment is a procedural issue and therefore should be examined under the law of the state where the action is brought. So it's a rendition of judgments. Now we're looking at scrutinizing here summary judgment. We'll get into that in more detail as we go along here. Arizona law governed the preclusive effect to be given to an Arizona judgment in an action brought in New Mexico. Applying Wisconsin law in this 2011 course here as a recognition of judgment of state court by courts of sister state. Okay, so there are some more interstate issues with judgments, and the single file judgment rule. Single final judgment rule. Okay, before we get to this, let's jump over here to the chat. Hey, Deanna, welcome. Good to see you here. The courts do resolve around money in the bench, in the bank, and all that. So yeah, that's what it's all going around. Because you see it, and this stuff should be read to everyone. Wouldn't it be nice that I just had this stuff in school? You know, it's like you could really be teaching this stuff to elementary school students to know basic principles, things like a single final judgment rule. How hard could this be? Let's see here. There can be only one judgment or one final judicial determination upon a single cause of action, one for one. And partial disposition of the issues in a lawsuit by the trial court resulting in piecemeal appeals is disfavored. Piecemeal appeals, I like that. A judgment may not be fragmented and granted on a part of a single cause of action, where an issue is not logically severable. That is, when fragmentation is not feasible. A judge having rendered and signed one final judgment has no authority to sign another one. Thus, after a final judgment is entered in a cause, the entry of a second final judgment in the same cause does not vacate the first. And if there is nothing to show that the first is vacated, the second is a nullity. Ooh, interesting there. As to multiple judgments in cases involving multiple claims or parties, see section 36. So, as you see, we're going down this rabbit hole. It gets more and more complex just when you thought it was simple enough. But again, these are all pretty much very logically defined and separated in very intuitive ways when you really look at the situations why you would want one final judgment for one controversy. Where separate trials were not ordered or had, there should be only one final judgment which should dispose of all parties and all issues, which is the intent of the courts, to dispose of those issues with the parties. All right, now we're on to section 10, judgment as debt. Now we're getting into some really nuanced stuff here. A lot of you probably didn't realize, and now you're going to learn something very important. A judgment represents a judicial declaration that a judgment debtor is personally indebted to a judgment creditor for a sum of money. It may also be described as a form of indebtedness, a debt of record, notice of the debtor-creditor relationship, or a new debt of the highest dignity. The plaintiff in the action in which a judgment is recovered against the defendant is the presumed owner of the judgment. Wait a second. Owner of the judgment. Debtor-creditor relationship. Debt of the highest dignity. New terminology to be used with judgment. We're getting a little deeper here now. As legislative interference with judgment, see section 11. We're about to get there. Here it is, section 11, legislative interference with judgments, vested rights doctrine, and judgment as to public right. Whoa, when does that happen? Fragmentation is not feasible? Well, yeah. I wonder if that means like child support. You can't separate a kid. Well, exactly. These things are where you need to bring up these points of law, principles of law. Again, the overarching theme of this presentation is the principles of law that guide judgments. Better late than never. Audit them, but welcome. If you win a judgment, you still have the burden of collecting the award, not necessarily, as you shall soon see. Let's continue. This legislative interference with judgments. Now we're looking over the vested rights doctrine and judgment as to public right. The vested rights doctrine states that once private rights are fixed by judgment, they are a form of property over which a legislator has no greater power than it has over any other form of property. Fixed by a judgment, they become property, and the legislator has no greater power than it has over any other form of property. A litigant may have a vested right in a final judgment, such as a judgment in the form of property that is protected by due process from destruction or impairment by subsequent retroactive legislation. Judgments within the powers vested in the courts by the judiciary article of the United States Constitution may not lawfully be revised, overturned, or refused faith and credit by another department of government. Thus, the general rule is that legislature may not destroy, annul, set aside, vacate, reverse, modify, or impair the final judgment of a court of competent jurisdiction, so as to take away private rights which have become vested by the judgment. A statute attempting to do so is unconstitutional as an attempt on the part of the legislature to exercise judicial power. The legislature may not, under the guise of an act affecting remedies, destroy or impair final judgments obtained before passage of the act, which principle prohibits legislation affecting the inherent attributes of judgments or annulling or substantially interfering with the right to issue execution and to collect the amount due, as well as the statutory reopening of previously decided cases. Now, that's a big mouthful here, but when you really break this down, you realize that the judgment in and of itself becomes a form of property with a value, and it creates this debtor-creditor relationship, which now opens up this whole rabbit hole. The principle prohibits legislation affecting the inherent attributes of judgments. Now, when you look at statutes or codes that could affect a judgment, that's overstep of legislature into judicial realms. With respect to legislative interference with a judgment, there is a distinction between public and private rights, and a statute may be valid even though it renders ineffective a judgment concerning a public right. Even after a public right has been established by the judgment of a court, it generally may be annulled by subsequent legislation. Now, that's public right, but there's a distinction between public and private rights. Public right, the vested rights doctrine, legislative interference, but remember that the powers vested by the courts of the judiciary, article of the United States Constitution, may not lawfully be revised, overturned, or refused faith and credit by another department of government. This right here is your constitutional protection here, is this, the judiciary article of the United States Constitution. Therefore, when there is a judgment, property rights fixed by a judgment, they are a form of property over which a legislator has no greater power than it has any other form of property. And if we're talking about private property, it's about any more greater power than it has any other form of private property. Now, of course, the public right and private rights is where the distinctions will lie. Let's get down to the cumulative supplements here. Cases. Once a plaintiff acquires a right vested by a judgment, it cannot be disturbed by the subsequent repeal of a statute under which it was obtained. So no retroactive loss of a judgment because it's become property, and it can't be disturbed by subsequent repeal of whatever statute it was obtained. And that's International Paper Company versus County of Isle of Wight, Virginia. Wow. County of Isle of Wight, isn't it? Over by Britain. Okay. The private rights of parties which have been vested by the judgment of a court cannot be taken away by subsequent legislation, but must be enforced by the court, regardless of such legislation. And as which laws govern judges, we went over. Here's some more cases. So, did you guys catch the significance of that? That judgments are considered property. Now we're on to the elements. Section 12, elements of valid judgments. Effect of passage of time. In order for a judgment to be valid and enforceable, the court which renders it must have jurisdiction of the parties, as well as jurisdiction of the subject matter. Also, the court or tribunal must have the power of authority to render the particular judgment. It is essential to the validity of a judgment that the court have both subject matter and personal jurisdiction. Generally speaking, when a trial court has both subject matter jurisdiction and personal jurisdiction, its judgment, even if erroneous, is not void. However, if the requirements for validity are not met, a judgment may be subject to avoidance. Avoidance. A judgment is void if the trial court 1. Lacks subject matter jurisdiction, 2. Lacked personal jurisdiction, or 3. Lacked the judgment in a manner that violated due process. Entered the judgment in a manner that violated due process. Observation: that a court acts in violation of a statute does not mean the resulting judgment is void. However, the judgment is void if the trial court entered a judgment in a manner that violated due process. Not violation of statute, but due process would void the judgment. Okay, see this distinction here, that when we're talking about due process, it's supreme to statutes, as you see right here. The passage of time, however great, generally does not affect the validity of a judgment and cannot render a void judgment valid. A void judgment is one rendered by a court which lacked personal or subject matter jurisdiction or acted in a manner inconsistent with due process. And a void judgment is a nullity and may be vacated at any time. At any time. Passage of time. Guys, if there's a void judgment, something that was rendered by a court lacking jurisdiction, which can be challenged at any time, inconsistent with due process, any time, a void judgment's a nullity and may be vacated at any time. Practice tip. While there may be no time limit in bringing a motion for relief from judgment on the ground that the judgment was void, delay may be a factor in determining what further relief may be available if a judgment is declared to be void. So time may be of the essence when you're claiming relief, it seems. Let's go over some of these footnotes here. A trial court's judgment is binding when it has the jurisdiction over the parties or property, jurisdiction of the subject matter of the suit, jurisdiction to enter the particular judgment, and the capacity to act as a court. Okay, let's see what else you get here. Where a court is legally organized and has jurisdiction of the subject matter and the adverse parties are given the opportunity to be heard, then errors, irregularities, or wrongdoings in proceedings, short of illegal deprivation on the opportunity to be heard, will not render the judgment void. So speak up while you're at trial. Free-form notions of fundamental fairness, divorced from the traditional practice, cannot transform a judgment rendered in the absence of authority into law. Wow. That's per Justice Kennedy, with 3 justices concurring and 2 justices concurring in judgment. Wow. Voidable judgments. See, a judgment is void only when it is apparent that the court rendering it had no jurisdiction of the parties, no jurisdiction of the subject matter, no jurisdiction to enter the judgment, or it could be any of these things, or no capacity to act as a court. That's 2017. As the due process requirement for valid judgment, we're going to get to that soon. Void judgments, violation of procedural rules or statute. And the mere passage of time does not constitute a ground for relief from an obey the law injunction or a reason why the prospective application of a judgment is no longer equitable. Passage of time will neither vitalize a facially flawed decree or judgment, nor immunize its plainly fatal deficiency from collateral attack. Wow, nice wording there, 2003 in Oklahoma. I'm not going to read this one here. That's all right. Let's go along to section 13, due process of law requirement for valid judgment. Before we go there, let's check over here to the chat. Hey, we have Captain Jack. Yeah, May versus Shall. That's my favorite case. Love referring to that one. Okay, let's proceed here. Due process of law requirement for valid judgment. Now, we just went over this in reference. Now we're going to get over it in detail. Wow, looks like a lot of detail. A judgment may not be rendered in violation of constitutional due process limitation and guarantees. A fundamental requirement of due process in any proceeding which is to be accorded finality is notice reasonably calculated under the circumstances to apprise interested parties of the pendency of the action. Gosh, this is a nice compound sentence. Let's read this one more time. A fundamental requirement of due process in any proceeding which is to be accorded finality is noticed reasonably calculated under the circumstances to apprise interested parties of the pendency of the action. For a court to issue a valid order or judgment, the court must have jurisdiction over both the subject matter of the action and the parties. To issue a binding judgment concerning a party, the court must possess personal jurisdiction over that party by virtue of his or her appearance before the court or by the lawful service of process upon the party. Jurisdiction refers to the forum's authority to adjudicate claims against a defendant, and service refers to the process by which a defendant over whom a court has jurisdiction is brought before the court. Both are necessary for a court to issue a binding judgment, but the two concepts are not synonymous. A judgment entered in absent sufficient service of process upon a defendant violates due process and is void as to the defendant for want of personal jurisdiction. Complete failure of service of process deprives a litigant of due process in a trial court of personal jurisdiction. The resulting judgment is void and may be challenged at any time. Thus, when the judgment roll fails to disclose that a party was brought into court by process as constitutionally due, the judgment rendered in the case is void on the face of the record and is subject to direct or collateral attack at any time. One is not bound by a judgment in personam in litigation in which one is not designated as a party or to which one has not been made a party by service of process, and as a consequence, a judgment or decree among parties to a lawsuit generally resolves issues among the parties but does not conclude the rights of strangers to those proceedings. However, these general principles do not always require one to have been a party to a judgment in order to be bound by it. For purposes of determining whether a prior judgment is binding on a non-party to that judgment, where a special remedial scheme exists expressly foreclosing successive litigation by non-litigants, as, for example, in bankruptcy or probate, legal proceedings may terminate pre-existing rights if the scheme is otherwise consistent with due process. So that's a mouthful there, but in addition, an opportunity for a hearing before a competent and impartial tribunal on proper notice is one of the essential elements of due process of law. A judgment is the final determination of the rights and obligations of the parties in a case. It may never be entered until after said parties have had an opportunity to appear and present their rights and defenses. Thus, all persons are entitled to an opportunity to be heard in a court of law upon every question involving their rights or interests before they are affected by any judicial decision on the question. A judgment is void if, in the proceedings leading up to the judgment, there is a violation of the due process guarantee of notice and an opportunity to be heard. So, an opportunity to be heard. Very important to be able to express this. And we'll get to footnote 16 in a second. Well, let's do that now. (2012). Interesting. Hendricks versus Department Stores National Bank. Okay, but no further elaboration on that footnote, so let's continue on. A final judgment entered without adequate notice of the hearing and an opportunity to be heard is void. The judgment of a court without hearing or giving a party an opportunity to be heard is not judicial determination of its rights and is not entitled to respect in any other tribunal. Not entitled to respect. Observation. The rule that a want of due process voids a judgment is not redundant with the rule that a want of personal jurisdiction likewise voids a judgment, for a person already effectively made a party to litigation could, on some critical motion for some critical proceeding within that litigation, be deprived of the notice, a hearing according to that notice, and a judgment entered in accordance with such notice and hearing required by the Due Process Clause of the 14th Amendment to the United States Constitution. So the Due Process Clause of the 14th Amendment is something that could come in helpful in certain situations, and you might want to express operating in that capacity in those situations. A judgment entered without notice or service to an interested party is constitutionally infirm in that the failure to provide notice violates the most rudimentary demands of due process of law. And without confirming, something infirm cannot be affirmed. As to necessity of notice for due process of law, see constitutional law, which we went over, section 983. I don't know if we went that far into it. As to elements of valid judgments, see section 12, which we did. And as to jurisdiction of court rendering judgment, in personam jurisdiction is the power to deal with the person of the defendant and to render a binding judgment against the defendant. Now, do you see this here? This wording here. In personam jurisdiction is a power to deal with the person of the defendant. The person of the defendant is the power to deal with the person of the defendant and to render a binding judgment against the defendant. This is 2004, Oklahoma. Person of the defendant. Generally, a person against whom a judgment or order is taken without notice may rightly ignore it and may assume that no court will enforce it against his person or property. As to effective status of record on validity of judgment. So a person who a judgment or court order is taken without notice may rightly ignore it and may assume that no court will enforce it against his person or property. Interesting there too. May rightly ignore it if without notice. See, a decree is void as to any person shown by the record itself not to have been before the court in person or by representation. So the decree is void, shown by the record itself not to have been before the court in person or by representation. So really good stuff here. A judgment that is rendered without jurisdiction, adequate notice, or an adequate opportunity to be heard need not be recognized or enforced. That's Unleaded Software versus TNF Gear 2016. Vermont, not too long ago. And we're on to section 14. Validity of judgment based on unconstitutional statute. The fact that a judgment in a civil action is based upon an unconstitutional statute or ordinance does not render it void or deprive it of its effect as a judgment. A judgment is not void simply because it is erroneous or based on precedent later determined to be incorrect or unconstitutional. This general rule applies where the issue of constitutionality was raised prior to the entry of judgment and legislation was erroneously held valid. If a civil court renders judgment on a claim that is within its subject matter jurisdiction, but a relevant statute is determined to be unconstitutional on its face, the judgment is merely rendered erroneous or voidable, not void. Woohoo, that's interesting here. A relevant statute is determined to be unconstitutional. Let's see. If a civil court renders judgment on a claim that is within its subject matter jurisdiction, but a relevant statute is determined to be unconstitutional on its face, judgment is merely rendered erroneous or voidable, not void. So it can't be ignored. All right. So we're on to section 15. Validity of judgment in violation of procedural rules or statute. An irregular judgment, which is voidable, is one rendered contrary to a proper result. An example, it is materially contrary to established forms and modes of procedure for the orderly administration of justice. So it seems like an irregular judgment is not very reasonable. A court's failure to follow proper procedure results in an act in excess of its jurisdiction, such that the judgment remains valid but voidable, and the parties may be precluded from setting it aside by waiver or estoppel. On the other hand, rules relating to service of process are mandatory, and the failure to comply with such rules renders the judgment void if the judgment is rendered against a party who was not served in strict compliance with those rules and who did not waive service or of citation or appear voluntarily. Not waive service of citation or appear voluntarily. The judgment is void because the trial court is without jurisdiction and is subject to direct or collateral attack. For example, in jurisdictions which prohibit an interested person from making personal service on a party, personal service by a party renders any judgment or order arising from the proceeding void, despite the defendant's actual notice. However, a claim of insufficiency of process, unsupported by facts and documentation, is not enough to upset a judgment. So claims are not as good as actual, for making a personal service in a party, yeah. And a personal person makes service, then that's considered void. All right, a substantial defect in notice renders an original notice fatally defective, and any judgment based on it is void. Woohoo! Substantial defect in notice. On the other hand, a mere irregularity has no such effect on the original notice, and a judgment based on it is not void but may be voidable, which means no. The fact that a court acts in violation of a statute does not mean that the resulting judgment is void. Typically, absent one of those rare circumstances that makes the judgment void, the mere fact that an action by the court is contrary to a statute or rule makes it voidable or erroneous. Where a statute authorizes a court to do a particular thing and the power of the court to act is subject to certain limitations named, then a judgment of the court rendered contrary to the limitations named is not void for want of jurisdiction or subject to collateral attack, but is voidable only. However, where jurisdiction is statutory and the legislature requires the court to exercise its jurisdiction in a certain manner, an act of the court beyond these limits is in excess of its jurisdiction, and where the court acts in excess of its authority, its judgment is void and may be attacked whenever and wherever it's asserted. So, nuances and further nuances, depending on the jurisdiction you're in, because that's the rules we're going to be following. Okay, and these are just the cases here that we referred to for that. Now we're on to section 16, validity of judgment affected by fraud or collusion. Ooh. The validity of a judgment may be affected if obtained by fraud, especially where the court was imposed upon and the complaining party was prevented from having its interests fairly presented or fully considered by the court. Fraud or collusion in connection with the rendition of judgment may render the judgment void or merely voidable. Fraud which prevents a court from acquiring jurisdiction or merely gives the court colorable jurisdiction renders the judgment procured by such fraud void. But fraud occurring after the court's valid acquisition of jurisdiction does not render a judgment procured by such fraud void. Void decree is one that has been obtained by extrinsic or collateral fraud, or was entered by a court that did not have jurisdiction over the subject matter of parties. So void, we're getting back to the void decree, void judgments. Final judgment obtained by fraud or ill practices is not an absolute nullity, but it is voidable. All right, we're on section 17, partial invalidity of judgment. And let's check on the chats. Read code or debug code? Yes. Well, they say you got to be about 10 times smarter to debug code than write code. So who's reading it? All right. In determining the validity of judgment, a part of it that is separate and distinct from the whole may be considered independently. In determining the validity, a part of it that is separate and distinct from the whole may be considered independently. Where part of a judgment is void, the entire judgment is not a nullity. And if the void provisions are severable from the valid provisions, the court may strike the erroneous provisions. For example, a judgment which grants excessive relief may yet be valid if, by striking the surplusage, the remainder may be separated and treated as dispositive of the controversy. So the excessive relief could be set aside. Surplusage. Oh boy, the valid part of the judgment is not dependent upon and is the valid part of the judgment is not dependent upon and is therefore separable from the void phrase which only concerns the manner of enforcement. Very interesting there. And we're on to section 18, effective status of record on validity of judgment. In determining the validity of judgment, resort may be had to the entire record, including the pleadings filed in the action. A decision is facially void if an inspection of its record proper shows that one or more of the requisite jurisdictional elements appears to have been absent. What are we calling this? The effects of the record on the validity. So if you go back to the record and see that some requisite element was absent, a judgment is absolutely void if it appears on the face of the record itself, either that the court had no general jurisdiction of the subject matter, or that the judgment is wholly outside of the pleadings and no consent thereto appears. However, an invalid judgment is not void in a legal sense unless its invalidity appears on the face of the record. If the extrinsic evidence is required for impeachment, the judgment is not void, but voidable, meaning further deliberation. On the other hand, the general principle is that where a court has jurisdiction over the person and the subject matter, and the judgment rendered is not in excess of the jurisdiction or power of the court, no error or irregularity can make the judgment void. It prevails, even if there is a fundamental error of law appearing upon the face of the record. Wow. So where a court has jurisdiction over the person and subject matter, and it's not rendered in excess of the jurisdictional power, no error or irregularity can make the judgment void. Again, it doesn't mean it's not voidable. It just means that that alone cannot make it void. It prevails, even if there's a fundamental error of law appearing upon the face of the record. So interesting stuff here. Defective notice must be revealed from the face of the judgment roll. And if extrinsic evidence is necessary to show the jurisdictional defect, the judgment or final order is not void. So we can't have extrinsic evidence. It has to be prima facie, on its face. All right. Now we're on to section 19, the court's jurisdiction to render judgment. All right, so whether a court is one of general or limited jurisdiction, it is essential to the proper rendition of a judgment that it be given by a court of competent jurisdiction. A court is a court of competent jurisdiction to issue a valid judgment if the court has jurisdiction over both the subject matter of the action of the parties, or both the subject matter of the action and the parties. Jurisdiction refers both to the power of the court to render valid final judgment and to the propriety of granting relief sought. And it is only when a court lacks fundamental jurisdiction to render judgment that there is an absence of authority in the court as to render its judgment a nullity. Jurisdiction is not a question a court can take or leave, and a judgment entered without jurisdiction is void. In order for, of course, this is something jurisdiction that needs to be raised. In order for a judgment to be valid and enforceable, the court which renders it must have jurisdiction of the parties as well as jurisdiction of the subject matter. A judgment is void if the court rendering it lacked subject matter jurisdiction or jurisdiction over the parties. A judgment rendered without jurisdiction may be attacked and vacated at any time, either directly or collaterally. Total lack of jurisdiction must be distinguished from an error in the exercise of jurisdiction. And an error in interpreting a statutory grant of jurisdiction is not equivalent to acting with a total lack of jurisdiction. Interpreting a statutory grant, wow. Not equivalent to acting with a total lack of jurisdiction. It does not render a judgment a complete nullity. If the court has subject matter jurisdiction, then the judgment, although erroneous, is merely voidable. And a judgment that incorrectly interprets a rule of law does not divest a court of jurisdiction over the subject matter or over the parties. Any error in the exercise of jurisdiction over a particular case causes a judgment to be voidable rather than void. So it's an error in exercise would make it voidable rather than void. Okay, so here's our observation. Lack of venue does not deprive a court of jurisdiction to hear a case. Oh, I've heard this one before. And judgments in such cases are considered voidable rather than void. That's footnote 12. Let's see if I'm familiar with this one. Kentucky, 2008. Bays. Okay, versus the Commonwealth. So, when a court decides a matter without having the court's jurisdiction, then the whole proceeding is null and void. An example, as if it had never happened. Without having jurisdiction, the whole proceeding is null and void. When a suit is dismissed for lack of jurisdiction, rulings on the merits rendered prior to the dismissals are nullities, void ab initio, right from the start. Cases here in our cumulative supplement. Jurisdictional errors can be of two types. Okay, here's our two types. Get your notepad out. A court can lack fundamental authority over a subject matter, question presented, or party, making its judgment void. Or two, it can merely act in excess of its jurisdiction or defined power, rendering the judgment voidable. Two types. So the type when they lack fundamental authority over subject matter, the person, question, or right, a party, question presented, or subject matter, its judgment is void. Those errors, right? Fundamental authority would render a void judgment. But if it's acting merely in excess of its jurisdiction, right? Just excess of it, not a fundamental lack of authority, just in excess of its jurisdiction or defined power, it would render the judgment voidable. Review denied 2020, so very recent stuff. Again, we're reading from a 2022 supplement, so these are rather recent activities in the courts. A judgment is void and therefore subject to relief under Federal Rules of Civil Procedure only if the court lacked jurisdiction or if the court's action amounted to a plain usurpation of power constituting a violation of due process. Ooh. As the fact that erroneous judgments that are merely voidable may not be collaterally attacked. Fact. And we'll get on to section 20 here. Court's jurisdiction to render judgment, subject matter jurisdiction. A judgment rendered by a court which has no jurisdiction over the subject matter of the action or proceeding is void. Such a judgment may be attacked in any direct or collateral proceeding where a person seeks to assert a right arising from the judgment, and at any time when a judgment is to be enforced or its validity is questioned. Either party, even the party that has invoked the jurisdiction of the court, can attack the jurisdiction at any time after the judgment is rendered. So, either party that invoked the jurisdiction of the court can attack the jurisdiction at any time, voiding the judgment. The issue of subject matter jurisdiction can be challenged at any time, and a court's lack of subject matter jurisdiction renders that court's judgment void ab initio, right from the start of all the proceedings. As a court's jurisdiction to render judgment generally, we saw that. And we're on to 21, the court's jurisdiction to render judgment, personal jurisdiction. To enter a valid judgment, a court must not only have jurisdiction of the subject matter, but also the persons of the parties to give validity to its final judgment. The existence of personal jurisdiction is a constitutional requirement to rendering a valid judgment, mandated by the Due Process Clause. Thus, only a court having jurisdiction over the person of the defendant, may enter a valid judgment imposing a personal obligation or duty in favor of the plaintiff. In the absence of jurisdiction over the person of the defendant, I love this language here, they're very clear about it, any judgment or order the court might enter against the defendant is void and may be challenged at any time. See, jurisdiction over the person of the defendant. Doesn't say jurisdiction over the defendant. Jurisdiction over the person of the defendant. Jurisdiction over the person of the defendant can be acquired only in two ways. Here we go. One, by service of process upon him or her, whereby he is brought into a court against his will. Oh, wow. Or two, by his voluntary appearance and submission. That's interesting. Against his will. A judgment rendered without proper service or entry of appearance is a nullity and void. The existence of personal jurisdiction depends upon the presence of reasonable notice to the defendant that an action has been brought. Reasonable. And a sufficient connection between the defendant and the forum state as to make it fair to require the defendant to defend in that forum. A default judgment entered without personal jurisdiction is void. A judgment rendered without personal jurisdiction is void, even if the defendant had actual knowledge of the proceedings. Such a judgment may be attacked at any time, and the waiver rule does not apply. In actions involving joint and several parties, it is improper to render judgment against all of the obligors where the court has not acquired jurisdiction over some of them. A judgment so rendered is void against the parties over whom the court has no jurisdiction. Thus, a judgment purporting to bind parties who were not served in the action is void only to those persons not served and their successors. So if you get roped into it, tough luck. All right, due process requirement for valid judgment, we saw that. In personam jurisdiction is the power to deal with the person of the defendant and to render the binding. So this is Kanoko and looks like Oklahoma, yep, 2004. Where the court lacked personal jurisdiction over one defendant, the default judgment is an absolute nullity insofar as it relates to that defendant, but is legal and final against the second defendant who was properly served. Sorry. As the several joint parties named in judgment. All right, and on this one, we're going to take a break here. For next time, we'll have the effect of consent on parties' court's jurisdiction to render judgment, because now we're really getting into the weeds, and I want us to leave with these essentials here because we really went over all the primary essentials of judgments. And this leads us down our path where we will learn about more of these elements of judgments and the different types of judgments, which we haven't even gone over fully yet. And I'll be saving that one for the next one. In the meantime, let's go over the chat here. I sign up to this. Yeah. Oh, yeah, that's right. Yeah, we make sure we're fully compliant here. On that note, let's see if there's any other. Let me refresh this chat here. And it looks like we're there. We're caught up. I hope everyone learned a little bit about judgments today and about the different, I guess, the nuances and all the fine points that would make a judgment either stand or nullify it or make it voidable, meaning that it could be attacked later with some serious defects, but certainly not something that could be ignored, which a void judgment may be. And it's just Jack? Okay. Yeah, well, that works. Either way, it's been a really good expedition here to learn about these different kinds of effects in the operations of judgment. And I'll say that what's going on for the next part 2 of this, we're going to get into the actual types of judgments that you hear so much about, summary judgments, default judgments, and the nuances with those. But having this background here is going to make that one just a breeze and easier to understand. And this way we'll have, a good toolbox of effectiveness when it comes to dealing with things like judgments and other actions of the court, decisions, verdicts, etc. Again, I'd like to salute you all for coming by here tonight and spending time here to learn a little bit about American jurisprudence. Yes, some serious dense information on this. Yes, greetings to Bill Thomas as always. It's been a lot to digest, but I believe that it's really been a lot of redundancy too because of the importance of these elements that we have to, really look at some of the details that go behind what renders a judgment valid or void or voidable, and then what actions we can further take to ensure justice. Well, with that being said, again, thank you all for coming. And salute you all for spending the time to learn more deeply about our precious common law here in America that's slowly, seeming to fade away in interest in the application. But with your help, we'll keep it alive. That said, salute to you all. See you on the next one. Peace out.